May it please the court, Your Honor, ladies and gentlemen of the jury. When I spoke to you at the beginning of this case, I told you that it would be similar to solving a jigsaw puzzle. You would need a frame and details in order to create a clear picture. And after we've heard all of the testimony from the witnesses and seen all the evidence and exhibits, I'd like to go back through with you once more those details, show you how they fit inside that frame, and then ask you for a verdict in my client's favor. At the beginning of this case, I asked you to consider a frame, and that was this: that danger and that delay for Waldman equaled danger for Levy. That for Officer Waldman to delay in firing his weapon would mean danger for the life of his partner. That was the frame and the big picture that I asked you to consider as we went through today's trial. And the first thing we heard from the eyewitnesses, those people that were actually there on December 7th. We heard from Officer Levy and the story of his altercation with Mr. Ramirez. We heard Officer Levy state he identified himself as an officer immediately upon stopping the vehicle and exiting his vehicle, and how Mr. Ramirez disregarded that identification and continued and eventually came to hand-to-hand combat. We heard from Mr. Ramirez. Mr. Ramirez claims the police did not identify themselves before the altercation, but admits to having at least 7 drinks in the very few hours leading up to the accident. Mr. Ramirez, who also claims not to own the knife that was used to stab Officer Levy, but can't explain the fact that the basketball game that he went to watch with his friend that night never took place. Mr. Ramirez, who claims the officers cut off his vehicle on his way home, but actually turned off his road home, off the street that would take him to his house, to follow the officers and intentionally confront them. Mr. Ramirez claims much, but remembers little. You also heard from my client, Officer Edward Waldman, and his state of mind when he was forced to shoot Mr. Ramirez. You heard Officer Waldman testify that as he saw the knife in the air raised to stab Officer Levy a second time, you heard Officer Waldman state that if he had delayed in firing, his partner could be dead. Now, the counsel for the plaintiff has made quite a big deal of Officer Waldman and the use of force and the police policy for the city of Chicago. And they had Officer Waldman read a portion of the training manual dealing with the use of deadly force and how it was a last resort measure. Ladies and gentlemen of the jury, if a knife is pointed at a partner, it is a last resort. They had Officer Waldman read the portion of the policy manual saying that a verbal warning should be issued or a warning shot should be fired. No, Officer Waldman did not issue a verbal warning. Mr. Ramirez had already disregarded Officer Levy's police identification, but with a knife in the air, there was no time for a verbal warning. There was no time for a warning shot. Firing a weapon in a residential area without care for where the bullet might travel would be reckless. But the counsel for the plaintiff, if they had gone a little further in that policy, you see the plaintiff's counsel left off one very important part. 2 very important parts before the policy portion that deals with the use of deadly force being a last resort. It says that a police officer is justified in using deadly force to prevent death or bodily harm to himself or another. Certainly, with a knife pointed at his partner, Officer Waldman was justified in using force. But the last portion of this policy manual, the plaintiff's counsel has overlooked. Police officers shall not endanger themselves to conform to this policy. Ladies and gentlemen of the jury, a knife in the air endangered the life of Officers Waldman and Ramirez, and Officer Waldman was justified in using force. In addition to the eyewitnesses, in addition to testimony about the knife and the use of force, we heard from expert witnesses, Drs. Angrist and Marshall. Now, the counsel for the plaintiff has told you that Dr. Angrist was the only physician to interview Mr. Ramirez, and so Dr. Angrist's conclusions and opinions should be accepted as fact. Yes, Dr. Angrist says the story with Mr. Ramirez is consistent with the medical records and with Dr. Angrist's examination. But with all due respect to Dr. Angrist, the examination of Mr. Ramirez by Dr. Angrist was superficial and cursory, because Dr. Angrist did not examine the gunshot wound of Mr. Ramirez. Dr. Angrist only examined a scar that was left from the wound, not the wound itself. The wound itself was examined by the witness for the defense, Dr. Winston Marshall. Dr. Winston Marshall, who was the physician on call on December 7th, who examined the gunshot wound, made his observations, made notes, prepared medical records. Ladies and gentlemen of the jury, those records, made the day of the incident, should be lent more weight than the examination of one physician of a scar. Ladies and gentlemen of the jury, you've seen the evidence. You've seen the knife. You've seen the medical records. You've heard the testimony from the eyewitnesses and the experts. For Officer Waldman to delay when a knife was in the air would have meant death or bodily harm, certainly danger, to Officer Levy. Police officers shall not endanger themselves to conform to this policy. Police officers are justified in using deadly force to prevent death or bodily harm to themselves or another. The details are clear. The details fit the frame. And as you begin your deliberations, I ask that you keep that focus on those details in that frame and return a verdict in favor of my client, Edward Waldman. Thank you.